एहसास न्याय का सबके लिए, आकाश न्याय का सबके लिए.
Hello everyone, this is Advocate Kabir Sabnis, and I have the privilege of introducing to you our guest speaker, Advocate Vibhav Amonkar. Advocate Vibhav Amonkar will be enlightening us on the evolution of rape laws in India. Now, without any further ado, I would like to call upon Advocate Shri Vibhav Amonkar to present his talk.
Hello everyone, I'm Advocate Vibhav Amonkar, and I will be addressing on the topic evolution of anti-rape laws in our country. Initially, when I was thinking of a topic under criminal law, I thought of criminal justice. But then I realized it was too wide a topic to cover in such a short time. So then I thought, let me focus on one particular offense, which is of some public importance. And then I thought, let me cover the issue of rape and the evolution of anti-rape laws right from the inception. So when we talk about rape, the first time rape was introduced as an offense in our country was back in the 1860 when the Indian Penal Code was enacted. Section 375 and Section 376 of the Indian Penal Code deals with the offense of rape. Back then, maybe it was not considered as a very serious offense, considering the minimum punishment for an offense of rape was only 2 years, which is a punishment for so many other trivial offenses as well. Although the maximum punishment was up till life imprisonment. There were primarily 3 types which was identified as rape. Number 1 was sexual intercourse without consent, sexual intercourse with consent when the consent was obtained under the fear of death, and sexual intercourse with consent when the consent was obtained under false pretense. There was also the statutory rape against a child, a girl of less than 16 years of age. These were the basic definitions of rape with the punishment which I had already told you. The statute continued this way for a very long time until the year 1972 when there was the case of Mathura, the Mathura rape case. We've all studied the Tukaram versus State of Maharashtra Supreme Court judgment, which deals with this particular case. What happened was a Adivasi girl was raped while she was in police custody by 2 policemen who were drunk on duty. The family of the girl filed a complaint of rape. They were arrested. There was a full-fledged trial, but the Sessions Court came to a conclusion that they were not guilty and acquitted both the policemen. The state filed an appeal before the Honorable High Court. The High Court reversed the acquittal and convicted them. They naturally filed an appeal before the Honorable Supreme Court. The Honorable Supreme Court came to a conclusion that there was consent involved here by the victim girl. They came to this conclusion on 2 grounds. Firstly, that there was no cry for help by the victim girl, and secondly, that there were no injury marks on her. There was a huge backlash to this judgment of the Honorable Supreme Court because the Honorable Supreme Court acquitted the accused. Lot of women organizations, public spirited citizens wrote to the Honorable Supreme Court, wrote to the government condemning this judgment because according to them they had misconstrued the concept of consent to that of submission when a girl is being submissive because she is in police custody but she is not consenting to sexual intercourse. It is on account of this particular case that the legislature introduced the Criminal Law Amendment Act of 1983. This act was the first turning point into the anti-rape laws in our country. What this did was it introduced a section to the Indian Evidence Act to deal with the concept of consent. When a girl alleges that she has not consented for sexual intercourse, and if the sexual intercourse is proven in a trial, then the burden of proof shifts on the accused instead of the prosecution. So how a criminal trial works is that the prosecution has to prove that the particular act has been committed by the accused. So the burden is entirely on the prosecution. But what this particular amendment did is it shifted the burden on the accused once there is a proof of sexual intercourse. So consent or absence of consent was presumed by the legislature by introducing this particular provision. There were several other additions also to the to section 375 and section 376. There were new facets to the anti-rape law, which was the concept of custodial rape, because this was a case of custodial rape when two policemen had control over a particular person. They committed the offense of rape while they were in control. So then there were policemen, then there were in charges of shelter homes where the women are lodged. So this was a new facet which was introduced in section 375 and 376 by this particular criminal law amendment. This continued for some more time. There was one significant aspect which was again introduced in the year 2002. What used to happen is on account of the whole trial, many women or victims of rape would not come forward to lodge complaints because they were scared that they would be made subject to a lethal cross-examination where their past, their antecedents, everything would be examined and everything would be questioned. Probably the defense would always want to hint at the immoral character of the victim to defend the accused. So what the legislature did was it introduced an amendment to the Indian Evidence Act which said that in an offense of rape, the immoral character of the victim was not material. Whatever may have been your past, whatever may have been your antecedents, that is not material in a criminal trial where a woman or a victim alleges that she has been forced to have sexual intercourse or she has been raped. This gave solace, or this gave protection to a lot of rape victims who then could come forward to file allegations or to file complaints without having the fear of being casticized in the witness box and being questioned with all sorts of things in the past. So this whole set of cross-examination which was being conducted till then was done away with this particular amendment, which also is a significant facet in the anti-rape law in India. In the year 2012 again, it was a study showed that maximum sexual offenses were against children. And at that time, it was found prudent to enact the Protection of Children from Sexual Offences Act of 2012, which is popularly called as POCSO. One of the most important things that POCSO did was it had no distinction between a girl child and a boy child. It just defined children or a child, and it did not say girl or boy. What happened thereafter was that any sexual abuse against a minor boy also attracted penal offense under the POCSO Act, and the act also introduced a lot of severe punishments for the offenders, which is also a deterrent for commission of this particular offense. I will not delve much into POCSO because it is an independent act in itself. But then what happened was by far the most significant or the most important thing that we have all seen. A young girl in Delhi was brutally raped by a group of men while she was on a bus. We popularly call it as the Nirbhaya case. The reason we don't name the victim girls was also the 1983 Criminal Amendment Act, which said that the identity of the victim can never be revealed. That act also introduced something called as in-camera trials to protect the victims of rape from being cross-examined in packed court halls. So the judges were given liberties to hold rape trials in camera when there is nobody except the victim and few other lawyers who are representing or who are involved in the case. All this was done to ensure that rape victims come forward, lodge complaints. There is no deterrent for them to come to the court and seek justice. Now all this happened, and then happened the Nirbhaya case. We all know what happened there. It led to such a backlash amongst all the citizens of our country that the government very swiftly enacted the Criminal Law Amendment Act of 2013. This has by far gone a long way into establishing or into this particular anti-rape law in our country. It enhanced the scope of rape, or it enhanced the meaning of rape, not only to mean vaginal penetration. It meant penetration in any part of the body, which included mouth, which included the urethra, which included the anus. So it meant that a lot of other factors were also introduced in the meaning of rape in the statute book. It also amended the IPC to bring the age of consent, which was 16 initially under section 375. It extended it to the age of 18 years. So what happened thereafter was any girl who alleged rape, who was less than 18 years of age, became a statutory rape, and there was no distinction the consent became immaterial. Any girl who alleges any sexual intercourse with a girl who's less than 18 years of age. Another very important factor here is that particular amendment of 2013 removed the judicial discretion of imposing a minimum sentence. So back then what used to happen is, before this particular act, the honorable courts were given the liberty to impose sentence less than 7 years if it felt that there were compelling circumstances. I had the opportunity of reading several judgments when a victim had filed of rape when they were having a love affair with the boy. The boy thereafter turned against the victim, which led to the victim filing a complaint of rape. After the whole prosecution was lodged, the victim and the offender, they get back and they get married. But however, because the rape or the complaint of rape was already lodged, and because it's a non-compoundable offense, the complaint could not be quashed. The trial had to go on, and the boy was found guilty because it was a statutory rape. But back then, what the courts had was that liberty to award sentence which was less than any minimum sentence. There was no minimum sentence which was prescribed in such exceptional cases. Now, for some reason, this particular judicial discretion was done away with, and now the courts did not have the liberty or the discretion to impose sentence less than 10 years. So minimum sentence was introduced by this 2013 Act, which is of 10 years, and the courts could not impose any sentence which was less than 10 years. That introduced several other amendments also into the Code of Criminal Procedure, into the Indian Evidence Act, to supplement or to strengthen the rape law. And it introduced two very important sections into the Indian Penal Code, that is section 166A and 166B. 166A deals with any police officer or any person in charge who refuses to register a complaint for rape. This was very important from the point of view of the police people who would refuse to register. That the refusal itself was made an offence under the Criminal Amendment Act. The second offence, that is 166B, was in cases where a hospital, whether private or public, refused to treat a rape victim. Now, these two offences were also introduced by the Criminal Law Amendment. So our legislature has always endeavoured to strengthen the rape law, to introduce new amendments in order to secure the victims, in order to expedite the trials, in order to bring the offence home and the offender home quicker than it generally takes. And all this has helped in strengthening the rape law or deterring the persons who are wanting to commit rape from committing the offence. But there is one thing which I would like to highlight in all this, and it is the misuse of this particular law which is happening in our country. And there is nothing right now that has been done to deal with this misuse except a case of malicious prosecution. What has been happening is there are several complaints where the offences are heinous, where the offences are extremely serious, but then there are other complaints which are filed implicating innocent persons only to vindicate some personal grievances. because of the various amendments introduced to rape law, it means that the consent is presumed. So the moment a complaint of rape is filed, automatically the machinery is invoked and the person is arrested. Nobody goes to verify whether, because it is a cognizable offense and it is a serious offense, nobody goes to verify whether there has been an actual sexual intercourse there or no. And this has resulted in implicating several innocent persons because the woman or the alleged victim in that particular case had made false allegations. Later on, all that happens is that the accused is acquitted, but the person who has made all these false allegations, nothing really happens to her. So there is one thing that probably our legislature has to take into consideration. Our legislature has to look into this aspect in order to deal with such cases of false accusations and false allegations. This was my time for dealing with the concept of the evolution of rape in India. I could only deal with how the various amendments have been enacted and what led to the enactment of all those amendments. Thank you very much.
Thank you, sir, for illuminating us with such a sensitive topic and helping our viewers understand the country's progression with regards to such rape laws. All the viewers, kindly do like, share and subscribe this channel. Thank you.
राष्ट्रीय न्यायिक सेवा प्राधिकरण
न्यायालयातल्या कारवाई खातीर बरो वकील मेळोवन दिता.
वेळार योग्य कायद्या खालची मदत आणि सल्लो दिता.
लोक अदालत द्वारा चड काळच्या केसीक बेगीन सोपयता.
आणि तेवूय सामके मोफत.
राष्ट्रीय न्यायिक सेवा प्राधिकरण बेस बरो न्याय बेस बरो समाज.
अधिक माहिती खातीर लागच्या न्यायालयातल्या न्यायिक सेवा प्राधिकरण कार्यालया लागीं संपर्क करा
वा टोल फ्री नंबर 151000 चेर फोन करा.